Slip and fall injuries, an Indiana overview. I have worked on all kinds of slip and fall cases. I've worked on cases where delivery drivers have been injured by an overly excited dog, resulting in a slip and fall injury. Many cases where people are hurt entering a store due to the snow being incorrectly shoveled, resulting in a slip and fall injury. And the most common of all, people are out shopping, slipping and falling on a puddle in the middle of the store, a hazard the store knew of or at least should have known about. Slip and fall injuries are more than just accidents. They encompass situations where, due to someone else's negligence or carelessness on their premises, a person is injured. In short, a slip and fall case arises when someone gets injured due to a hazardous condition on another person's property. In Indiana, property owners have a duty to maintain their property so it's safe for visitors. What does the law define as a visitor? In Indiana, there are 3 types of visitors. The first are called invitees. These are people actively encouraged to visit someone's property. Friends, delivery drivers, or anyone that's essentially told, hey, come on over. Invitees are owed the highest duty of care. That is the duty to exercise reasonable care for their protection while they're on the landowner's property. The second are called licensees. For them, there is a duty to warn of any known dangers. Licensees are those who are tolerated on a person's property without an explicit invitation. Indiana has made this category very murky, but the best example I can think of is the middle schoolers who hang out on my yard waiting for the school bus. I don't really want them there, but I agree it's better than them waiting in the street. The third type of visitor are trespassers. Surprisingly, even trespassers have rights in Indiana. A trespasser cannot be intentionally harmed by a landowner. For someone to recover from injuries on another's property in Indiana, they must prove liability. The challenge with slip and fall injuries typically is the lack of objective evidence that an injury occurred. For example, in a car crash case, there's usually objective evidence that at least something occurred, such as visible vehicle damage. With slip and fall cases, the evidence is much more subjective, making medical records, witness information, and photographs so very important. Yet imagine this scenario. A person is shopping, they slip and fall and are injured. Their priority is likely getting medical attention and not trying to collect evidence. But not collecting evidence can lead to a bad outcome in a slip and fall case. Does this sound like a catch-22? It should, because it is. And that is only one of the many pitfalls of a slip and fall injury case. And that doesn't even account for the time restraints in a slip and fall case that can limit a person's recovery. It is so critical to contact an attorney as soon as possible after a slip and fall injury. A skilled slip and fall injury attorney can guide an injured person through the complexities of a slip and fall case. In Indiana, by law, an injured person's primary duty is to get better. That should be the injured person's only focus. Let a professional slip and fall attorney handle the legalities. A skilled slip and fall attorney can investigate, secure the evidence, and ensure nothing crucial is destroyed. In summary, a slip and fall case in Indiana involves someone getting injured due to hazardous conditions on another's property. Slip and fall injuries can be frustrating to the victims involved. Let the Marc Lopez law firm turn that frustration into compensation. Give us a call, 317-632-3642. If you found this information valuable, don't forget to like this video and subscribe to our channel.